and welcome to the program. I'm Roby Brock. As always, thank you for joining us. Well, it flew somewhat under the radar, but a little over a week ago, in a landmark 9-0 ruling, the U.S. Supreme Court stripped away regulatory powers from the Environmental Protection Agency when it comes to pollution control in U.S. waterways. The ruling will narrow the EPA's regulatory authority. The decision is being hailed as a win for property rights advocates, especially farmers, while being touted as a blow to environmental protection efforts. Now, while the court was unanimous when it came to deciding who should win the lawsuit, it had a 5-4 split decision on how far the EPA should be able to go when it comes to regulating wetlands. To break this down, I caught up with Brigit Rollins, attorney with the National Agricultural Law Center. Joining me now is Brigit Rollins. She is an attorney with the National Agricultural Law Center. We are pleased to have her with us. Brigit, thank you for joining us.
Thank you for having me. I'm very happy to be here today.
All right. This Supreme Court decision that we're going to talk about today that impacts agricultural land, waters of the U.S., there was a 9-0 decision. There's a 5-4 decision. So for people who aren't familiar with the Sackett case, explain what the 9-0 decision was. What was the 5-4 decision?
Yes, absolutely. It is kind of confusing because you see both these terms come up. So the court agreed 9-0 in the outcome of the case. So they all were on board with the final decision not to regulate the wetlands on the Sackett's property as a water of the United States. All the justices signed on to that. The 5-4 part comes in because the justices did not all agree on the reasoning. So you had 5 justices, a majority, signing on to the opinion authored by Justice Alito. However, not every justice agreed with Justice Alito's reasoning, and they opted to write their own concurring opinions or to sign on to another concurring opinion. So that's where you get that discrepancy. 9 justices, the total of the court, agreed in the legal outcome, but not all justices agreed in the legal reasoning.
Do you think that the result of this lawsuit is that the EPA, the Environmental Protection Agency, will have to revisit its definition of what a water of the U.S. is? And did we get any direction on what that might be?
Yes, I do think they're going to have to revisit their definition. Right now, their current definition is kind of referred to as the 2023 rule. It went into effect March 20th of this year. A lot of what is in that rule no longer, it just does not comport with what the court has said in this Sackett case. So EPA is going to have to revisit that definition. They have said as much. If you look at the statements they've put out, they have said that they are currently reviewing the rule, considering their options. And right now, that's about all we know. It's hard to say at this moment what EPA is going to do going forward, whether they're going to launch an entirely new rulemaking or whether they're going to do sort of what they did in 2006 following the most recent Supreme Court decision where they issued some memoranda kind of directing sort of their agency officials on how to proceed.
You contend to, in an article that is on our website at talkbusiness.net, that two of the things not addressed by this Supreme Court decision is levees for flood control and the fact that they are not waters of the U.S., and then what's known as dry beds. I'm going to ask you for a little bit of definition on the levees and what that kind of debate was about, and then what dry beds are, which we're not as super familiar with in Arkansas. These are 2 big farming issues, so they really have some potential big impact.
Absolutely. I'm going to go ahead and start with the levees. One of the big outcomes of this case is that only those wetlands that share a continuous surface connection with a recognized water of the United States are going to get regulated as waters of the United States themselves. So according to Justice Alito's opinion, if a wetland is, say, prevented from sharing a continuous surface connection with a recognized water of the U.S. by a levee or some other kind of man-made berm, it's a little unclear whether or not those wetlands will be regulated under the Clean Water Act. This is actually something that Justice Kavanaugh touches on in his concurring opinion. He kind of points out it's really uncertain whether or not such wetlands would no longer be regulated under the Clean Water Act. They were under the previous understanding of waters of the United States, but following this case, it's a little unclear. And as anyone who lives along the Mississippi River knows, those wetlands and that levee system are very important for flood control. And that is certainly something that Justice Kavanaugh brought up in his concurring opinion, and it has definitely been something that commentators have been, kind of focusing on. Is it's a little unclear now what that means for those wetlands. The same is going to be true for dry beds. I'm from the West Coast, so I'm a little bit more familiar with this kind of water feature. So we're talking here dry beds, or another term for them might be ephemeral waters, right? These are waters that do not run all year long. They might be dry during the dry season, but then you have, a rainy season, whether that's winter or a monsoon season, like you get out in states like Arizona. Suddenly these beds that are dry are filled with water, and they, drain into these other water bodies that are clearly recognized waters of the United States. And under previous definitions of WOTUS, sometimes these have been regulated as waters of the United States, and sometimes they have not been. But for the most part, these ephemeral waters have tended to be included in the definition of WOTUS. And one of the things that this Sackett opinion does is it limits the water bodies that can be identified as a WOTUS, or a water of the United States, to open, flowing, commonly accepted water bodies. Alito says streams, lakes, rivers, and the ocean. And again, it's very unclear then where that leaves those ephemeral waters. And this is something else that Justice Kavanaugh raises in his concurring opinion, and that commenters have been focusing on as well, is can these water bodies be regulated now as a water of the United States under this Sackett opinion? Even, they're dry, they might be dry certain times of the year, but when they are running, they do drain into recognized waters of the United States. So it's very unclear what their status now is going to be.